Fine.
Good to see you.
So it looks like we have 53 people in here, which is great. The only thing that we're going to need to think about is questions and such, because I'm not going to see anybody when they're raising their hands. So maybe if you can put something, I have my chat open saying you have a question, we can do it that way. I don't mind if anyone interrupts while we're doing it. Well, I know train of thought, but first I want to thank you all for being here. And I want to introduce you to my staff in case you don't know them. And so we have David Herrera, who is my court coordinator, and he usually doesn't have his video on. He usually just has the state of Texas here. We have, where is he? Bob Thomas, who is my court reporter. We have Orlando Diaz, who many of you may not know. And Orlando is going to share his cell phone with everybody so that you can text him and let him know when you're running late or if you need anything.
I don't think with
We're going to, Ana Sanchez is staying with us as our court, court administrator is her official title. Judge Pelletier, I believe, is on here. Her court reporter is Jason Mestas. Her bailiff is Cesar Anchondo, who I know everybody knows, and I think he already has everybody's cell phones and you have his. And Gina Arias, my paralegal, is a court coordinator for Judge Pelletier. And then we also have the Title IV court, and I see Ray Perez, who is with one of our Title IV judges, and he is actually retiring next Friday, so we'll be wishing him well then. And then we also have Lawrence Dominguez, who's the other Title IV court. And I think that hit everybody, if I'm right. Did I miss anybody? So I'm going to actually go ahead and let my staff leave unless they want to stay on, with the exception of Judge Pelletier. And we're going to, I know that actually Elena Gresham is the one who thought that this was a really good idea, because I think everybody got their policies and procedures and there was a lot of questions that came out of that. And I know that your staff probably would love to ask questions while you have us. So I'm going to ask everybody to maybe, I can do it, mute themselves for now. Just so we don't have the background noise, and then jump in the chat if you have a question. So I'm going to go ahead and get started. Oh, also, I wanted to remind everyone, I was sick on January 1st. Judge Gutierrez swore me in remotely. So we're going to do a robing ceremony on Friday. Miss Nichols and Judge Gutierrez will be helping introduce me, as well as my daughter, and we'll have our staff here at the courthouse and staying socially distanced for that. So some of the changes that you're going to see that we're trying, and I want to point out, all of these are fluid and subject to change. If you get back to us and give us input and tell us you don't think these things are working, I'm never going to forget that I came from the private bar and I was doing it for 20 years. And so if something is making your life harder rather than easier, we do really welcome the feedback. None of this is personal, and we want to try and make this court work for you and your clients. So one of the changes we have is the fact that we have one Zoom ID for each court. I believe everybody has gotten those Zoom IDs. That allows you to provide those to all your clients. It allows you to know what to put on your TROs, on your orders, and that will remain. Again, of course, reminder, we have a Zoom policy that was sent out separately. We're asking that you maybe have a Zoom hearing before your hearings with clients, just to troubleshoot some of those issues. We've had some issues this week with that. And one of the things we've learned is you can have your client change their name when they enter the room, so they're not just, you know, Galaxy 6, and that would definitely help us knowing who to bring into the hearings. And of course, as always, please don't record the Zooms and all that sort of thing. Some of y'all may have had some emails from me and Judge Pelletier in the past, and they are I guess I like to call them our personal county emails. We don't always check them quickly, so if you really want a hearing or you want to send exhibits, we may not look at those until the next day or that afternoon. So we have two different emails. The Associate Court has kept the same email. They use it for hearings and they use it for exhibits. And I believe everybody has at the 383 Let's see. Judge Pelletier, do you want to give them your Zoom and your email again?
Yes, 383fc2@epcounty.com. I'll put it in the chat.
Perfect. And that one is for both her exhibits and for her hearing requests. Now, for our court, we have two emails. We have the 383dc@epcounty, and that one's for hearing requests. Both Anna and David will be checking those. And then we have another one, which is for our exhibit submission. And that one is our 383 district court spelled out @gmail.com. That allows you all to upload Google Drives, and we're working with the county to try and see if we can create a Dropbox where every Friday we would send you a link with your cause number and everyone could just upload their exhibits into there. But right now, that's something we're still working on. I think I posted, and if you don't have it, we can send it to you. We have our hearing request forms already online. I've sent a Google link out to everyone that has our rules of practice, the Zoom request and the hearing request forms. If you have not received it, go ahead and email us at the 383dc@epcounty.com, and we'll be happy to send those to you again. A lot of folks are asking how we're assigning cases. So Judge Pelletier and I are assigning them on a rotating schedule. They're going to be done automatically and quickly as soon as we get a new case. We're not assigning them based on the complexity or who the attorneys are or any of those things. And the referrals will be done immediately and automatically.
Judge,
Yes.
can I ask, can you send those email addresses on chat, just like Judge Pelletier did, please?
Yes, if David, are you still on? If
Yes,
David,
Judge, I will do that. Thank you.
can you send those emails and clarify what they are? So we're trying out different patterns. You know, I'm going to go ahead and we're going to work with you know, a 2-to-1, a 3-to-1, just depending on how many cases that allows us to take care of, which with each one of the courts. One of the changes we have is Judge Rivera, the Council of Judges is very kindly allowing us to use Stephanie Clark, who works for the Council of Judges now, as a temporary court coordinator. So she will be responsible for continuing to schedule the remaining cases that Judge Rivera has. We did find when we got into our office, that October, November, and December, virtually all of the newly filed cases got referred out. So there are a fair number of cases that will be remaining with Judge Rivera. And so because of that, because of her heavy docket and our heavy docket, we were lucky enough to get Ms. Clark, who will be arranging those hearings, sending you notice, and hopefully it'll allow us to streamline those cases. We'll probably try and assign certain days in the future for Judge Rivera's docket so that we don't overburden the Council of Judges, because they're very short on court reporters. Going back to the referrals, we don't feel particularly, if the case is assigned to me and you happen, when we get all back to court, you happen to be in Judge Pelletier's courtroom and you want to put an agreement on the record, let her know. We'll do a referral immediately and you can go ahead and put that on the record so that you don't, sorry, my phone went off, so that we don't have to worry about waiting for an uncontested to hear it in my court. We're not feeling very territorial about those things. So that hopefully will help your life somewhat. Does anyone have any questions so far just with those issues? Nope. Okay. One of the things, especially during COVID, is on our hearing requests, we have a little checkbox where you do need to tell us if you need an interpreter. It is really hard to get interpreters, and everybody who does family law knows we're always the last one to get one after criminal court, JP, everybody else. So if you click that, that would really be helpful so that we can have one already arranged for your hearing. I'm going to actually let Judge Pelletier talk about this on the hearing request forms, and it has to do with fields and all those tech kind of things. So I'm going to let Judge Pelletier tell you about the hearing request forms.
So some of your offices have been sending over hearing request forms for us to fill in. but have restricted the fields so that I can only add information about the hearing where it's been shaded in blue. The problem with that is I frequently like to add in reminding that this is a Zoom hearing, telling you it might be a backup hearing, putting a date, that kind of thing. And that might go in the margins of the body of the hearing request form itself. So please check your forms. Typically, I'll send it back to you and say, please resend it without restricted fields. And I think there's a couple of offices that might still have that issue. Most of y'all don't. But I'm not sure if the DRO does that. I think the OAG, they send their orders with field restrictions. And I need to be able to put that I'm only recommending, especially if it's an order after contested. So does everybody understand what I mean by restricted fields? It really limits where the recipient can add any information on the PDF. So anyway, that would help a lot if we didn't have that.
And one of the reasons is we're trying to be an entirely paperless court. So we're taking advantage. Zoom, one thing Zoom did for us this year is learned all of that a lot better. But that way we don't have to print, scan it and send it back. David is requesting with my court that when you do send those hearing requests via email, that you do include in the subject line, and I believe actually that would be the same for Judge Pelletier, cause, the case, and the type of hearing and the length required. You may notice that with the county, if you don't put something in the subject line, you'll get it kicked back to you anyway. So this is a really good way for us to be able to find those hearing requests quickly in our emails. We're going to continue doing uncontested dockets 9 to 11, or you can request them at any time. If you don't want to wait, there's a lot of pro ses on Friday mornings. 11 o'clock is when we're going to be doing those that require an interpreter. And of course, we have a lot of folks who are taking advantage of just submitting the decrees with a sworn affidavit. And that's, I think, a really efficient and effective way to get some of these done. Does anyone have any question on that?
Judge, what do you mean by a sworn affidavit? And if sworn, can it be an unsworn declaration, or does it have to be a notary jurat?
I believe it has to be notarized, but it can be in whatever form as long as you're meeting those jurisdictional requisites. So there is a question, and this is something that we're still trying to decide. I was at a conference last week, and there was a judge who was an extraordinarily bright judge who told us that she does not even require hearings for her divorces, that she does the same what we do with our SAPSers and our mods. You just submit them to the court. I emailed her to ask her for some authority on that, but if there's any authority or ability for us to do that, we will absolutely try and implement anything that makes your life easier. We do plan on trying to continue a Zoom docket even when we go back to court for uncontesteds. I know what it was like to go down there for one uncontested on Friday when you had tons of work in your office, and so our goal is to make life easier for everybody. That would be correct. If it is a default, you would need to have an actual hearing because we would need to call out the name, we would need to do all of that sort of things. But for agreed, waivers, all of those type of things, yes, you can submit them with the affidavit.
Can we do that? Can we do on written questions with the default if we call the name out? Like if we have the hearing, but the attorney is just using the deposition.
Sometimes I know that we can get feedback from everyone. Attorneys like to ask questions that followed up, you know, especially if there are substituted services or things like that, to make sure
that's right,
that all of those were done well. If you submit something and we can't do it, we'll just set you for a hearing. So, okay, Mr. Dropping, I think you asked if you can just show up. I would advise that you not. I can tell you that uncontesteds take far longer via Zoom than they did in person, because we, especially with the pro ses, we have to pull the petition, we have to check the service, we have to check the returns, all of those things, and we have to review their decree. I would suggest, and I do take attorneys first. So if you pop in, we do a 9 o'clock docket, a 9:30 docket, a 10 o'clock docket, a 10:30 docket, and an 11 o'clock for uncontested, and schedule a bunch for each of those. If an attorney pops in, I do take you first out of order before the pro ses. But if you have something uncontested, we'll set you on a Wednesday at 8:30, and that might just be easier and quicker for all of y'all anyway. So whatever makes things easier for you all. Is there another? Okay. We are requiring for contested cases the children first or any kind of equivalent. It's not going to be a reason where we don't, we write something in like there's no possession or access, or we won't sign the decree, but we will require everyone to do it. And there is a list of the virtual ones. We'll accept anything if it's accredited 4 hours and online. Mediation. David will be sending out the forms if you want to be considered for mediation. We'll continue to use the wheel policy as we've done in the past, unless there's good cause shown or you all have an agreement. We would ask that you actually add your rate somewhere on there, so that if we have maybe 2 pro ses who need to mediate, we might, for good cause, choose someone who's willing to do a sliding scale. So please include that on your form. And that goes the same for amicuses and ad litems. We'll send out forms for that. We will be using the wheel, but go ahead and let us know your rates so that that's something that we can consider. We will be requiring mediations for all cases over a day, absent some sort of good cause, like an enforcement or serious family violence, all the traditional things. Yes.
Are you going to go through the DRC? I mean, they're requesting.
Thank you for that. I did forget that. So we will allow the DRC to be utilized as well, because I know they have much reduced rates. However, I am requiring that only be the attorneys.
Going off screen so I can take a bite.
Okay. We're only going to utilize the attorneys. The DRC has a lot of non-attorneys there. But they do have about maybe half a dozen attorneys, so that we would.
I know.
So that is one of our requirements, but thank you for reminding me of that. We are going to require waivers now for any hearing over 2 hours with the associate court. That doesn't mean if you start a hearing and all of a sudden you're at 2 hours and you realize you need another hour, we're going to make a fuss, but we ask you all in good faith to sign those waivers, or your case will be subject to cancellation or resetting. And that would be for temporary orders, finals, any of those things. Does anyone have any questions on that? And yes, in the chat, someone asked, yes, those would only be required for the contested cases. I keep calling it COPE, but it's children's first. So let's see. Oh, on temporary orders, since you all now know we have one Zoom, I would ask you all to include, of course, in your TROs and your orders to appear, our Zoom ID. Once we get to hearings, it would be helpful, especially if there's attorneys, that you just have your notification ready in case you have to show us, yes, I did advise this attorney, they are aware of this hearing, because we can spend a lot of time trying to figure that out. And I think you've all experienced what we have, which is everything via Zoom seems to take almost twice as long sometimes. So please, and I know that as a private attorney, I was guilty of this too, but now that we're here, try and advise the courts realistically about how much time you're going to need. Especially now, we don't have as many backups because of Zoom. So it would really allow us to allow people to get quicker hearing dates. And now I know why Judge Anderson would yell at me about that when I would cancel hearings last minute. So it'd be really nice if everybody tried to let us know, even if the reset form isn't in, shoot David an email, shoot Gina an email and say, we are going to agree to this and reset it. And one of the reasons is I take half an hour every morning and half an hour during my lunch to review all the pleadings. That allows you to come in and not have to worry that I am not familiar with what's happening. And so because of that, it would allow me to look at the next case or the next case so that we can be prepared if we do have a backup. So that would be great. One question that came up is on the TOs, we're not going to bifurcate them. So if Ms. Davis, you request a TO and then Ms. Sipes requests a TO on her divorce, we will set them together. And that's the only type of hearing where we will piggyback. We won't piggyback on enforcements with motions to confer or motions to compel unless time allows. But on those temporary orders, it makes sense for us to hear them together. And our docket right now, at least, is pretty good that we're able to get everybody in pretty quickly. I know Judge Pelletier has always been able to get people in on TOs, usually within about 2 weeks. So that is our plan. Our court is committed to ruling every Friday. So in the morning after my uncontesteds, I've set aside time. that I will rule on anything that I don't rule from the bench. So you will not wait for your orders, you will not wait for your rulings, and that hopefully will allow you and your client some resolution, because I know that's one of the things that we always are the messengers for our clients when we don't get a ruling, and we're always the one who gets the flack. So that's something we're really committed on doing. And any questions on that? Okay. Oh, I did forget to mention on temporary orders, if everybody could exchange their last 3 pay stubs, if spousal support or child support's being recommended, and exchange those with counsel and have their last tax return ready, or a W-2 or 1099 or something. That will allow us to move things, give you the best use of your time. We will require financials, because again, that also allows us to move these cases quicker for you. One of our issues is ex parte temporary restraining orders, or anything with extraordinary relief. We are asking that you clearly label the title is such that there's something that's beyond the pale or beyond a plain vanilla TRO. And please bold that language in there. I am reviewing everything, or Gina's reviewing everything. But if we start finding that people are trying to sneak things in that they shouldn't be in ex partes, you know, we'll be remembering that. And so I think it's just ethical to put everyone on notice that there's something extraordinary in that TRO. We will require scheduling and pretrial orders for jury trials, terminations, and bench trials over half a day. We'll be setting them about 30 days out, and we'll hear all pending motions. If we need to, we'll do another pretrial, 7 days before a jury trial if there's outstanding issues, or if any party requests an additional one. I think everybody knows tomorrow Judge Anderson and Heather Ronconi are doing a discovery rule. I don't know how many of you all have looked at this, but there are some pretty serious death penalty type sanctions almost in these new rules. And so please ensure you're in compliance with those issues when we go to trial. Exhibits. So we are asking that you exchange with each other and provide to the court by noon the day before a hearing. However, that will not necessarily be a reason to exclude evidence on that basis alone. So what that means is if you send something to the court, and what we will do is we will screen share it, we will not be looking at it so the other counsel can look at it if they haven't, and based on its admissibility or objections, we will allow it. We're trying to make this as close to what it was like to walk into court. I know for a lot of you, clients like to give you 40 text messages before you walk into a hearing, and we recognize the reality of that. But we would really, if you want to use your time best, exchanging those and sending them to the court would be extraordinarily helpful. We are asking everyone to include a table or a list of exhibits with some sort of a description. So R1 could say photographs of respondent and children. But we'll be printing those so that we can keep track of what's admitted or not. Do not send your exhibits to the court reporter. For us, the Gmail address, and for Judge Pelletier, her address. And like I said, hopefully we'll be able to get a Dropbox option, but that's in the works right now. Any questions on any of that or anything, Judge Pelletier, you want to add? Is she eating still? Hold on.
No, I know, right? No, I think you covered it, and I did add a hearing request form that we use. I put it in the chat for anybody who's interested. I know some of you have them. They've gotten so, I don't know, they've gotten kind of messed up after being refaxed and resent and so forth. So there's a clean one in the chat.
I think David has, oh, yes?
When you subpoena a witness with a subpoena ducis tecum, bring to the temporary orders hearing certain documents, which you may or may not want to use as an exhibit, how do you get them to you a day in advance? For instance, Judge Gutierrez wants them 7 days in advance, and you have a medical record that you're trying to get, and you have them subpoenaed to the hearing. What do you do in that case?
So that's really why we're trying to use that Dropbox. And it's something that CPS has been using for years when they get the voluminous records from hospitals and police departments, because they send them a link, they can upload them into the Dropbox. And that's why we're working on that. I think for now, if you suddenly get those medical records, we would ask them to send them to you, Ms. Sipes, email them to you. You're going to have to multitask and determine whether those are exhibits that you really need, and then we'll take it as it comes. Then you'll have to share it with opposing counsel. And then I don't think we could screen share, 300 pages of medical records. Obviously, that could get very tiresome, but maybe give you all a recess if it's a long hearing to allow you all to discuss its admissibility. We understand those things happen, and you just can't get those records. And I know how some of those things work. So we're going to work with you all to make this hopefully as streamlined as possible, help preserve your time, but understand what it's like during Zoom. Hope that answers your question. It's not really an answer. It's sort of like we're going to try and help you help it work as best as we can. And this actually I think goes back a little bit to the fields. If you're doing motions and orders, I know what it was like in ProDoc when you would draft them, they often draft all together. Please separate your motions and your orders, like an enforcement or a motion to withdraw, because if it's in what you filed with Odyssey and the orders attached, we can't sign them. So it goes back to kind of like that enabling field. So send us the motion and send us a separate order in order for us to withdraw. And so on those, we are going to allow those by submission only. If someone has an objection, they have to file their objection within 3 days to those type of things, and then we'll take it up on hearing. During COVID, we're asking you please to include an email for your clients when you do a motion to withdraw. It allows us to communicate with them easier. So we would really, really request that you add that email. Does anyone have any questions about that? Dismissals. So the first two we're going to do with staff only via, our preference would be via email. So if you see you have a dismissal February 1st, there is no reason that you need to wait till February 1st. You would either contact David or Gina, let them know what you need, if you need them to set it, to reset it, to set it for a final hearing, to set it for a judge's conference, communicate with them. So the first two DWOPs will be with staff. After that, the third one will be with the judges and with the court. And what we're really going to try and do is set the DWOPs a little closer in time on some of those. I know sometimes they're 90 days out, which means you end up around 9 months with cases getting reset and reset. So we might cut those dates a little bit shorter, but you won't need to do those with me or Judge Pelletier until it's become sort of a chronic issue. Does anyone have a question about those? Because I know there was always a lot of dismissals in this court. Okay. Substitute service. Please, and I know Judge Pelletier and I talk about this almost every other day, please make sure they pass muster. You need your efforts. You need something creative other than publication. Judge Pelletier, do you want to add to this? Because I know we've talked about this a lot.
So remember that when you're asking for a sub-serve, we not only need the affidavit from the process server who was unable to serve, but we need to know why that process server is going to that address. So typically the client is going to have an affidavit saying, I know he lives on this street because that's where I dropped the child off and picked the child up. So that's one affidavit. And then the other one with the process server. If the process server says, I went to the door and there was somebody that answered that says no, that they've lived there for 5 years and nobody that you're looking for has ever lived at this address in the last 5 years, well, then I'm probably not going to allow posting on the front door at that address. So just look it over and make sure it's reasonable. Also, if you're asking for a citation by posting, it cannot be in a case where there are children. So the citation by posting on the courthouse door can't be in children cases, and we still get a lot of that. And if you've served citation by publication, it's probably going to be a default. Don't forget your statement of evidence when you come in for the final hearing.
And don't forget your note that the notice of default judgment that the district clerk needs to issue. I've had a couple of cases, and that can always affect any of your appellate or post, trial remedies. So one little extra step. Protective order. I think that I saw Judge, am I muted? No. I think that I saw Judge Gutierrez on here, if I'm correct. Our standalone county attorney protective orders will be referred to the protective order court. If there's other matters pending, other family law matters, et cetera, we will retain the case. So if you filed a divorce and then the county attorney files a protective order, we do keep it. But if the county attorney is just filing their standalone, those will go to the protective order court. Any questions on that? We are requiring inventories and appraisals on any cases involving property over $50,000. Now that is somewhat flexible. They might have one house, obviously, that's worth more than $50,000, and that's their only asset. So you don't have to do an inventory and appraisal with that. But please know that whenever you provide those to the court and we get something that we can use as a roadmap, it's extraordinarily helpful. But what we are asking is for all final contested hearings that you submit a proposal if there's property custody or possession and access. You can e-file it, you can send it to our Gmail as an exhibit, but it's very helpful, and I think it honestly saves time for you as well. You don't have to have your client go through what's the house, what's the address, how many cars do you have, what are their makes? Because if you've given me or Judge Pelletier a proposal, we can at least go through and get to the meat of the hearing rather than those sort of background information. We are asking that you provide us as well an editable version, so it's something that we can use when we're doing rulings and such. Is there any questions about that? If anybody has any outstanding rulings from Judge Herrera, please contact David so that we can set up a conference to discuss those options. I've had a couple of people reach out, and we need to think about the most cost-effective and way for us to resolve those cases. So each will be on a case by case, but please reach out if you know that you're waiting for something before Judge Herrera left the bench. We are filing all orders, including the OAGs, including the DROs, and including private. So we will not be e-signing them and sending them back. We will e-file them ourselves. And so you'll get your e-file service.
Judge?
Yes, who am I talking to?
This is Amy Nichols. Judge,
Hi.
on the adoption orders that were e-filed, we are not able to access them without an order from the court. Would you consider a standing order to release those?
Yes.
So that we don't have to do a motion and order on each one?
We can do that, and we can also at least make sure that we email you a copy of it once we get it filed as well. We do that with some of the pro se's who may or may not have, emails that they check or correct emails. And that's actually one of the reasons we're requesting pre-trials on terminations and adoptions, just to make sure everything's ready to go before you get in there. So that will allow us to send you the final order as well.
Okay, that would be great. The ones lasting from the former bench, we need to get all of those released.
Okay, so, and that actually goes back, if there is something, not even an order, but even a signature such that is pending, maybe if each of your offices could get that kind of list together, send it to David, and we will either resolve with a copy of that order so that we can sign it. If there's additional issues, you need a contested entry of judgment, we'll try and handle those as best as we can. Obviously, we didn't hear the case, but we don't want you having to get transcripts or relitigating a case all over. So whatever you and counsel can work on or agree upon to resolve these matters, we'll accept those. But yes, we'll help you on those if there's something outstanding, Ms. Nichols. And I guess just one sort of last thing. Philosophically, we want to make it clear, and I think people know, Judge Pelletier and I are definitely adhering to that philosophy that children need to have frequent and continuing contact with another parent who have shown the ability to act in their best interest. And that's why we're asking you all to do proposals. We're both supporting creative possession and access schedules beyond that rebuttable presumption of an SPO. And if you give us a visitation possession and access schedule that supports that, you might get it. If you want to enumerate specific things about rights and duties, if you think they should be independent, subject to agreement, all of those things that go into proposals mean that we will consider those. But we want to definitely have everybody, including ourselves, thinking outside the box. And I just want to sort of end with, I know we can't come in, but we do plan on having an open door policy. I want you all to let us know what works and doesn't work. I did what you all did for over 20 years, so I won't forget those pet peeves we all had from the family bar, but this is a work in progress. If somebody has a better idea than we had, or something isn't working, we really, really hope that you will share it with us. And I know it's hard. I remember what it was like. It's hard to give judges feedback. I get that. And maybe I know that Ms. Hartshorn, you were talking about hopefully having elections and stuff soon. Perhaps it would be great if we went back to having that liaison that we used to have in the past, where you had, one person or 2 or 3 people who feel comfortable enough to come in chambers and just say, you know what, Judge, this really isn't working. We need to talk about this. And I am absolutely receptive to that. I don't think I have the only way. I don't have any ego in regards to that. We just want to make this work for everyone. So that's kind of it on the Q&A. Now, does everybody?
Your Honor?
Yes,
Your
Ms.
Honor,
Thomas?
I have to ask you to go over entry of judgment on the submission docket, if you would do that. That's a very confusing issue, and we would ask you to please go over that.
Okay, let me pull that open real quick.
That's on page 4.
Yes, and I have 2 different notes up here, so I'm trying to get into both of them. And unfortunately, on one computer, I can't access certain documents. So give me 1 second. And I think I did mention, and I can add it in the chat in a minute, that we have everything in a Google Doc, in a Google Drive as well, that you'll be able to access. I would ask, I know there's a lot of people not on social media, but the El Paso bar on the Facebook page, I think, has been a really great way for people to share information. And it seems to be getting more active, which is great. So this is actually something that's a little bit of a what would you call it? An exercise to see how this works. And so one of the things we had requested is that certain motions, including what you might consider to be contested motions, could be heard by submission. So my preference is, of course, that you set a contested entry of judgment, but we've all been there where we keep sending an order, we keep sending an order, we keep resetting, and nobody is signing that order that you've drafted. Upon that, if you do that, you can do a motion for an entry of a contested entry of judgment. After 10 days, we will sign that order if nobody files an objection. So it's kind of a proposed decree, but it'll allow hopefully people to get these orders entered. Now, that being said, the moment we get somebody, contesting the entry, then we'll set it for a full-blown contested entry of judgment. But I know that sometimes it can take 9 or 10 months to get these orders in when you don't have the involvement that you need from opposing counsel. Some of the other things we did, and I think some of these are obvious, would be the motions for alternative substituted service, consolidations, nunc-pro-tuncs, depending on whether, of course, there are more specific issues that need to be resolved. Motions to confer with child will do the same way. If you file a motion to confer, nobody files an objection, 10 days later, we'll go ahead and sign it. Reinstatement, again, I think that goes fairly obvious. Withdrawal, substitution of counsel. And for some of the pretrial submissions, when you have a shorter but contested case, you'll just be doing those pretrials by submission. You won't have to do them in front of a judge. And I think that was pretty much it. Now, at any point in time, you can request a hearing. Don't get me wrong. This is just hopefully to allow you all to move your docket a little more effectively.
Ms. Lovett, Artalejo Lovett had a question about service by social media. And I suppose we're really talking about service by Facebook Messenger. That's how it comes up most of the time. And when that idea was first introduced and talked about, it was always Facebook Plus. So you'd always have, you serve them by Facebook, but then you also have, maybe the petitioner also sends it or has some discussion, or there's also a posting or something like that. The problem with Facebook Messenger, it's difficult to tell whether or not the person actually read it, because many people won't open Messenger if it comes from someone they don't know, like a process server. And so we had talked about that, Judge, the other day about things that the process server could do. You talked about doing a joint, sending it jointly on Messenger with petitioner and from petitioner and the process server, so that perhaps the respondent would open the messenger from the petitioner, right?
Right. So I mean, Facebook's going to be a legitimate method, or I guess Twitter or Instagram or whatever, if you can prove that those are valid methods of communication, WhatsApp, things like that. But I guess our biggest concern would be, I don't know about you, but I don't open messages from people I don't know. And so if we thought you might be able to solve that problem, if you had them CC somebody, for example, the petitioner or the person requesting that. I'm sorry, I'm trying to open this up. Here we go. But no, be creative about your substitute service. All we want is we're not going to just sign publications or postings de facto unless legitimately that's the only way of doing it. And in fact, I think it's a lot cheaper to do some of the other ways. Any other questions? Any thoughts? Yes.
I have one. I'm working with another bar director to have with the Supreme Court task force to have a uniform policy around the state for Zoom, even after COVID. And it would be something like that any attorney in a non-contested case can be heard by Zoom sort of automatically. And in a contested case, there would have to be an agreement by the attorneys on the other side. We want something uniform for the whole state. Would that work in your court? I mean,
yes, I think Judge Pelletier and I have talked about trying to take advantage of Zoom even after COVID for administrative hearings, kind of, motions to withdraw, pre-trials, things like that. And so that is absolutely something we can continue to use.
Gosh, Mr. Fisher, if you've got an interest in advocating for or against Zoom, one of the things we're struggling with is the live stream, because we can see the number of people who are watching, but we don't know who they are. And so if an attorney has invoked the rule, it's problematic when there's people watching the live stream. Plus, when we had open courts before Zoom, open courts meant someone would walk in, but I could assess that person and determine whether or not they were, a witness, or if a person walked into the courtroom and they pulled up their camcorder, we would tell them that we don't permit the videotaping. Well, the problem with the anonymous viewing is that you really can't tell whether some of that's being done, and it could put the parties, and worse, the children, at risk.
right. That's it.
And I'm not sure they thought about us, again, as usual, the family bar. I mean, I think it's different being in a criminal hearing or a civil hearing than it is for some of us, where we have a lot of HIPAA protected information, where we have a lot of information regarding children. I mean, we've all had those cases.
But for those of us that have the standing number, we have an open court. Anybody can log in. I can be in a case with Mr. Smith and yourself, and if it rings, I let people in. So I feel like we have an open courtroom without the live stream. And so I know that when Office of Court Administration initially set it up, they didn't really do that with the understanding that you could handle it that way. They've got one Zoom number every time you have a hearing. But I wonder if it would make a difference if I post my Zoom number on our website and anybody can log in all day long and watch hearings in the court. Then do you still have to do the YouTube and the live stream, especially in family court?
Right, the YouTube, yeah.
And there are procedures for limiting public access via live stream. If you have any questions, you can email me about that. But, by agreement of parties, based on that the evidence, that there may be, there is not, the evidence has, or the, I'm not speaking correctly about this, but you would have to describe what that evidence is and be really clear about why there should be no live stream and whether the public interest can overcome that presumption. So, sometimes with something regarding children, I know Judge Gutierrez with the CPS cases uses that quite frequently. But if one party objects, it's going to be pretty unlikely that we're going to, not live stream it.
But bring that up to us so that we know you've got an objection or you're uncomfortable, and talk to your clients about that and their risks and everything. I think there may be a responsibility to let them know what that means, because sometimes I try to delete those recordings soon after the hearing, but sometimes you get busy and they may be up there for a little while.
And I think what the standard is if we find that the evidence is of such a nature that the protection of the evidence or the witness overcomes the presumption of public presentation. So that may be important. I know we've all had cases where we have interfering family members, and we don't really necessarily want them sitting on Zoom, on YouTube, listening to all the testimony, and then it gets back to everybody. So just keep that in mind. And if we have alternative methods, like Judge Pelletier said, if we limit the live stream, we can notify everyone there is a Zoom that you can enter, but at least that way we can make sure everybody isn't listening to what may be very difficult testimony for the parties. I see a question from Patricia. Going back to the mediation for hearings in excess of 1 day, what safeguards are you going to put in place to prevent abuse of that policy? If I'm understanding the question, if you are requesting a hearing that's going to take more than 1 day, that's when you're going to be sent to mediation, or upon request or discretion of the court if we think it's a good case for mediation. But there will be an automatic referral if the case is over a day. So it's when you make your hearing request that determination is going to be made.
Judge, my concern with respect to that is, and we know it happens, certain attorneys may ask for 1 day just to simply prevent the hearing from proceeding in a timely manner. And that's my question about how we're going to prevent against abuse of that. So I don't hold on to the kid for 4 months because I need a day-long hearing.
So every single of these policies that we have are subject to a showing of good cause. So if you file a motion objecting to mediation and you give me a good reason why I should at least just get a hearing set really quickly and not wait for that mediation and scheduling, we'll absolutely consider it. So what's going to happen is if we know that the hearing is more than 1 day, David's just automatically going to send a referral to mediation. That doesn't stop you from requesting a hearing objecting to it. Any other questions?
I have a question. If we have a proposed division, do we also need an inventory?
Not necessarily. For the inventory we had put in there, and I think all of us have experience that very few people actually file or do inventories. So I would suggest if you have multiple pieces of property, multiple 401ks, TRSs, TSPs, et cetera, an inventory and appraisement may be necessary, or of course, if the court orders it in any specific case, but the proposals would be fine in lieu of those inventories. And that's not going to be a reason we're not going to proceed with the hearing.
Okay.
And Judge, I think you said earlier you wanted those in editable form?
Yes, I don't know who's
like
talking.
a spreadsheet?
Yes.
All right.
Any other questions?
Judge, when is that course on discovery that Heather was going to do? I apologize.
That's okay. It's tomorrow at noon. It's Judge Anderson and Heather Ronconi are both doing it to get a perspective from the bench. And that may, of course, start changing some of our issues with the requirements. They have much more stricter deadlines on some of these things. And that will be on this same Zoom, on our court Zoom.
Which Zoom is that going to be?
The one you're on right now, the 963-054-3532.
All right, excellent. Thank you.
And I think, as I mentioned in the beginning, we're doing my robing Friday. That's the same Zoom as well. Any other questions? Any thoughts? Anything we've missed that you think that the court should be thinking about or considering?
Can you just, excuse me, Judge, but can you reiterate what you're going to be doing on Friday mornings? Is that going to be the uncontested docket? Because I also thought you said something about doing uncontested during the week.
Correct. That's where we're having our uncontested docket for mostly our pro ses. So if you have something and you want to get it heard that week, David will stick you in someplace on that Friday. But what I'm saying is if you have something uncontested and you don't want to sit in that line, like if you were in the courthouse, you can request any time of the week to hear your uncontested.
I will just say this. I hope that you will keep the Zoom hearings as much as possible, even after the pandemic, because it is actually for somebody like me that works 15 miles from the courthouse. It's nice to just be able to. I saved a heck of a lot of money in gas. I'm sure I'm not alone.
And that is one of the things where we'll have to figure out, but you could be, if the parties agree, like there's two attorneys and they want to do the hearing by Zoom, I'm not going to have an objection to that. But if you want to take care of a pretrial or an uncontested and you request a setting via Zoom, then we'll have specific times that we can schedule those. Those things we'll kind of have to figure out once we get back to work in person. But I agree with you, Mr. Mullen. Well, practicing law or the administrative and just the day-to-day part of practicing law should be easy.
Right.
So.
And what I'm saying is that for the routine stuff, you really should be doing it by Zoom. I don't think there's, the more contested cases I can certainly understand. We need to be down at the courthouse, but some of the easy stuff, let's stick with this. If it ain't broke, don't fix it.
I do know one of the things that I was hoping, and that maybe we'll get feedback when we have a new family bar elected, is I've thought about having some standing orders because there are some things that just go without saying that everybody should be doing with their litigants, but I don't want them to be long and complicated. I want them to be as simple as possible because I think you're more likely to get compliance from parties. And I don't know about you all, but most people don't even read through a 5 or 6 page TRO. So if we had a 5 or 6 page standing order, that could get complicated. So mostly just dealing with real simple things like don't start changing beneficiaries, don't pull all your money out of the bank accounts, don't change schools, don't move. I mean, if depending on the circumstances, the injunction. So we're working on that. It'd be great to get some feedback from the family bar about how you feel about it. The only reason I'm considering it is the last conference, most of the other jurisdictions have standing orders.
Right. In
an ideal world, I would love it if all the courts had the same standing order. And I know I've spoken to Judge Gutierrez about that. We've kind of broached the subject with Judge Rodriguez. I know that would be easier for all of you. And so that's something that's in the works, but maybe just think about those type of things as we move forward and how you feel about that. Anything else? I guess, is that it? And don't, feel free to email. Actually, going back to the original thing where I asked you not to use our personal email, or when I say personal, I mean our EP County emails. That kind of works the same for David, Gina, and Anna. They monitor that email that I gave you before, which is the 383dc@epcounty.com. They have it up on their computer screen all day. They don't always have their personal ones because we get so many things from the county on there about, various things. So if you want that hearing and you want it to be noticed quickly, those are the best emails to use rather than I call them our personal emails. Anything else? I guess not. Well, thank you all for joining us. And of course, if you think about anything afterwards, please do not hesitate to reach out to us and ask us. We did record this, just so you know, so we can email it to your staff or anybody who couldn't attend today. And we did put it on YouTube. And rather than removing it from YouTube, it will stay up on YouTube. So it is something that you can access or your staff can access, at least for the foreseeable future. I know not everybody was able to make it or have all their staff or their attorneys. I know we have some staff without attorneys. So that will hopefully answer any questions that you have.
Thank you, Judge, for just doing this so that we can be, since everything's new with you,
And I
Good
want to
that
thank,
they will
I
do
can't
that.
take credit for this. It was actually, I think she left. It was actually Miss Grashheim who had this idea. So
Sure. Yeah.
is she back in your courtroom? Okay.
Yeah.
And my goal is actually, at least during our first year on the bench, is to try and do something like this, just an attorney Q&A, and maybe we incorporate it into the family bar meetings where we get feedback. And that's really what we want to do, is get as much feedback. All I know is I'm sure as many of you thought, when I was in the private bar, I would always say, gosh, I wish judges did it like this. And so we want to hear those, gosh, I wish judges did it like this part of it. At least the ones that I forget.
Judge, pardon my interruption.
Yes.
I saw that we got Judge Pelletier's hearing request form. Is yours the same? I understood we were to get one, but we haven't yet.
Yes, they will. Actually, they will be the same. And it's in the chat. I put a Google link. In that Google link, if you click on it, you can access our policies, our Zoom policies, and our hearing request form. That being said, if you all, after this hearing, need another copy, or for whatever reason you can't get into Google Drive, email the 383dc@epcounty.com, and David will immediately send you that hearing request form. We're actually using a hearing request form for both the courts, where all of the Zoom information is on it. We've streamlined it and removed some of the ancillary things. And hopefully it'll be nice and clean and easy to
Yeah,
use.
and I apologize because I had put one in that's strictly for associate court, but use the one that's on the Google Drive. It applies to both. I'll accept any request for hearing folks, but we really want to be consistent and use the same one, so you all don't have to keep so many different files for so many different courts.
I'm
Right.
glad you're getting responses back quickly. That does help.
And so, yeah, I mean, if you want to send us a motion in an order setting hearing, we're fine with that too. I mean, it's the devil. We're not worried about those details. We're worried about getting you all set.
So you're not.
Thank you, Your Honor, for
Thank
making
you.
this effort. It is very much appreciated.
But you're not going to have very many backups anymore?
Well, we will. The problem is with Zoom is life is just a little different. So we do have backups. And actually, one of the things I didn't mention it today because it is in the policies and procedures, is we would welcome everybody logging in about 15 minutes early. Because we have one Zoom, the moment you come in, David will put you, opposing counsel, and your clients into a breakout room. I know how many of us settled cases at the courthouse, 10 or 15 minutes before hearings. That's harder to do right now. So if you log in 15 minutes earlier, then you can chat with the opposing counsel and your clients and maybe come to some sort of agreement. We're happy to do that if you come into a hearing, but you don't always want to eat up your time doing that, I know.
It's also good that you have familiar staff, people
Yes.
that you've seen before.
Yeah, so we have a good hybrid. David is amazing. He anticipates my needs before I even ask him for something. I'll ask him, hey, don't we need this order? And David's like, already got it, or whatever. Oh, there's David. He popped in.
Let's be careful that he doesn't get a big head.
And then we also have Gina, who really understands family law. So that's very helpful for all of y'all. In terms of getting things set. She really has a really good understanding of the realities of what these hearings mean. So I'm really proud of my staff. I'm very excited to have them. Oh, I do know someone had just texted me. Someone had asked me about the referrals to Judge Rivera. Judge Abel's, the way he put it is you can't do any, give backs or take me back. So if something has been referred to Judge Rivera, of course, it stays there unless, you haven't had your hearing, she's never called the case, there's been nothing signed, and you have your objections, to visiting judges as you can. In the event that happens, Judge Abel's will be referring those back to me. I think we had one the other day that there was an objection. Judge Rivera had not heard anything, so that it did get sent back to us. But we do plan on using I have spoken to the other family law judges, and we definitely intend on using our visiting judges for very limited purposes, exigent recusals, conflicts and such. But I know that there had probably been a little bit of a resentment in the past from some of the judges about the amount of time the 383rd used visiting judges for. So it is definitely our goal to handle our docket unless, you know, there's some sort of medical emergency or such. And we will be transferring cases out internally. That was another part. There are a lot of cases I imagine Judge Gonzalez and myself have been attorneys on. We would ask you actually bring that to our attention as quickly as possible. If you know that I was on a case and it's in the 383rd, let David know immediately, and we are transferring them amongst ourselves. We're not sending them to ABLE, so we can get those set very quickly by either sending them to CC5 or to the 38th, and we're just alternating, depending on there being no conflict. Anything else? Well, thank you for taking your lunch to do this. I hope it explains some things. I hope it makes your life easier. If you do have any ideas, please do reach out to us. And I would ask that you all maybe consider working on having that court liaison. I think would be valuable. Because I know there was tons of things that I really wanted judges to know that they didn't know about. Noon tomorrow is the discovery CLE, and the robing is noon on Friday as well. Okay, if that's it, again, thank you for all coming, and I'll see you on Zoom soon, I guess.
Thank you, Judge.